have some really great speakers, so I'm going to try and get us started. And we're going to do things a little bit out of order. Rebecca is on her way, our chair, so she's going to introduce the speakers and introduce the topic and everything, and moderate a little bit. But just so that we can get started on time, I will quickly give you the legislative update first, so we don't have to do that at the end. So the legislative update, the last meeting we talked a little bit about, for those of you who were here, the two priority issues that this committee brought to the CBA to be part of the CBA's legislative agenda for this year. So one is to update and make the prayer for relief part of the Code of Civil Procedure more plain language for everyone, and the CBA did approve that to be part of their package. So session is starting this week and next, and so we will be looking for sponsors and getting that bill drafted. We'll keep you updated once we have a bill number and a sponsor. And then the other piece of legislation that we talked about was plain languaging the civil asset forfeiture statutory language as well. A little bit more complicated than the prayer for relief. So we, the way that the CBA has done it is that they've approved it in concept, and we'll be bringing it back to them once we actually have language drafted by LRB. We really wanted Legislative Reference Bureau, since they're the experts, to have eyes on that and figure it out with us. So more to come on that, but we're hopeful that that will get final approval, and that and then we'll be able to again do those sponsors and bill numbers and all of that. So we will keep you updated. But Rebecca is here, so I'm going to turn it over to her. But now we don't have to do legislative at the end. Stay good. Yeah,
hi everyone, I'm Rebecca Rashi-Kuroki from CBOS. Sorry I'm a minute late. Thank you all for coming to the annual highlights meeting. Please don't forget to sign in for CLE credit if you haven't already. And Angela might have already mentioned this, but the full highlights booklet is available on your tables. And outside, it will also be made available online at the Chicago Bar Foundation's website, and will be emailed to everyone after the meeting. So before we get started, I just want to thank all the organizations who submitted highlights this year. It is really an incredible list of accomplishments and victories and lawsuits and litigation and policy changes. It's just inspiring as it is every year, and so I want to thank all of you for the work that you do and encourage you all to read the full list and to share it with anyone you like. It's really important for us to spread the word about the great work that we're doing. We could have chosen any of these projects to be highlighted today on our panel, and they all would have been inspiring and impactful. It was actually really hard for Angela and I to choose who to select, and so we decided to choose some speakers today who are going to highlight projects that really impacted large numbers, huge communities, and also topics that we don't always address in this group. Prisoners' rights and environmental law and the fight to keep the school open. These are not things that we always see in our month-to-month meetings, so we thought they would be interesting and exciting for all of you to hear about today. But I want to take a minute to note that while our panelists are going to speak about major victories that impacted large communities and groups, we know, and I know, that this is not what most of us do from day to day. Most of us, including me, are meeting with individual clients, working on individual and small cases, if you will, and I know that I sometimes feel that maybe the work that we do is sometimes overshadowed by larger organizations and sexier victories, and so we just want you to know that we appreciate everything that you do in your daily work, and that you are really the heart and soul of legal aid, and thank you for everything that you do. On that note, I wanted to run through a quick list of people that you have helped and protected this year, so that we make a note of everything that's in there. So quickly, a few people and groups that you have helped and protected and supported this year. Tenants facing evictions, victims of domestic violence, veterans and their communities, the elderly, at-risk children, victims of human trafficking, children exposed to lead, people in motorized wheelchairs who need access to transportation, victims of sexual harassment and domestic violence, parents with limited English skills, debtors in bankruptcy, unfairly prosecuted youth, Illinois residents on Medicaid, youth in foster care, people with past convictions facing barriers to employment, consumers, the homeless, students in special education, immigrants in detention, and families separated at the border. That's a lot of people. So just a quick round of applause to all of you. favorite meeting of the year, and reading the summary of all your work is really inspiring and makes me so proud to be a member of this group. So without further ado, I'm going to introduce my panelists. Thank you so much for coming. Today we have Kate Gladstone from LAF and Candace Moore from Chicago Lawyers Committee for Civil Rights. They are going to speak about their recent successful fight to keep National Teachers Academy open and to prevent the use of racially discriminatory criteria in CPS school closures. A lot of us have read about this in the news. Some of us were at the Daily Center. I know my coworkers were to hear that decision, and that was an incredible win for our community. So thank you for that, and we look forward to hearing about it. We also have Tanya Gassenheimer from the Chicago Coalition for the Homeless. She's going to speak about their recent successful enactment of the College Hunger Bill, which now ensures crucial SNAP benefits to more than 40,000 low-income community college students in Illinois. We have Keith Harley, who is the director of the Environmental Law Program at the Chicago Legal Clinic. He's going to speak about the organization's victory in Clean Air Act litigation, which forced the closure and conversion of a number of coal-fired generating units, and this resulted in drastically reduced air pollution in northeastern Illinois. And finally, Alan Mills, the executive director of the Uptown People's Law Center. He's going to discuss 3 related highlights against the Illinois Department of Corrections that ensure basic human and civil rights for prisoners, including access to constitutionally adequate health care and mental health care, and accommodations for prisoners who are deaf or hard of hearing. So thank you so much, congratulations, and we look forward to hearing your stories.
Okay. So Candace and I are going to start talking about our school closure case. The school that we were working with is called National Teachers Academy. Sorry.
For all of you, just pull the microphone out of the stand, because otherwise you won't.
All right.
Right up in here.
There we go. Can you hear me now? Perfect. Okay, so National Teachers Academy is an elementary school located in the near south side of Chicago. It's an elementary school that serves K-8 students, 80% of which, at the time we filed, were African American. About 76% came from low-income families. The school itself stands at the site of the former Harold Ickes homes, and it is a level 1+ elementary school in Chicago, which means it's the highest academic quality that the city has. It's also efficiently utilized, which means it's full of students by CPS's assessment. And it also provides a lot of wraparound supports for its students. So it has an on-site health clinic, it has a park district partnership, it has free extracurricular activities and low-cost childcare. All around, it's just an amazing school, and the community is very invested in the services that it provides to students. Also, what comes with NTA is really a history of displacement. So students who were going to NTA when Harold Ickes was torn down actually watched their homes be taken down around them while they were in school. The school itself has been a receiving school for other closings, so there are many kids that go there now that have been displaced by school closings in other neighborhoods, 2 of which were our plaintiffs. And in the spring of 2017, CPS decided that it wanted to close NTA so that its building could be used for a new high school. The South Loop already has a high school. They just wanted a new high school in the gentrifying neighborhoods around. So there was no fault of NTA. There was nothing that NTA did wrong. CPS just wanted their building. And I think LAF and CLC really approached this from a race equity perspective, but so did our clients. They really made this a case that focused on what had happened to students in the past and what was happening to them now. So Candace is going to talk a little bit more about our plaintiffs and how we worked together.
Thanks, Kate. So the plaintiffs that we ultimately worked with for the case were 7 African American students, 4 African American mothers, and 2 community groups. The parents and the students represented students who were part of the gifted program. So one of the things that was really important was to demonstrate the issue of the impact on Black students, but also to raise that it was a really diverse set of Black students and parents that were all going to be impacted, to really isolate the issue of race. So it was parents that were part of the gifted program, parents and students that had formerly experienced school closings, parents and students who had special education needs, parents and students from various economic backgrounds. And so that was really important as we were thinking about the plaintiffs of the case. And just to backtrack just a little bit, kind of even how we got to the case was we at the Chicago Lawyers Committee for Civil Rights were contacted by some folks who would then form an organization called the Chicago United for Equity. And one of their roles in all of this was really helping to bring together the community to have a conversation about race and race equity when it came to the plan for their school. So what they did is they ultimately had 3 town halls in which they prepared what's called a race equity impact assessment, and that became a really important instrument not only to bring the community together and talk about what other options are even available, but to really discuss and talk across lines about what folks were experiencing. LAF was contacted by a woman, Anika Matthews, who also served as a plaintiff, but then also brought parents together to create a group called Concerned Parents of NTA. So those both Chicago United for Equity and Concerned Parents of NTA became our 2 community organization clients. And funny enough, Kate and I were at one of the community meetings, and we said kind of, oh, hey, what's going on with you? And so we were talking about sort of how we came to this work and realized that it made a lot of sense for us to work together. And it was kind of like, what would this look like if we filed a lawsuit together, our organization? Do you think it'd work? So it's kind of funny how that got started. But one of the things that was really important to both our organizations was to approach this from a community lawyering perspective. We had the benefit of really working with a community that was really working very hard to come together and think about what was needed for both their students, but to really think about some of the larger community needs. And they were doing an excellent job, an amazing job of raising the issue as a race equity issue, putting forth alternatives, putting together reports. And so we asked the question of what is our role at this moment in which they're doing this organizing, especially around the administrative process. What is our role? It's really to support them in preparing the best case, the best testimonies that they possibly can with some knowledge that we had from work that we had done previously around school closing. So the first leg of it for us was really just supporting that community in testifying at all of the hearings, making sure people understood what legal issues were at issue and where. Because in a community hearing, you only get 2 minutes to testify, so you got to kind of pick what you want to talk about. And so really giving parents, and saying, tell about what's going to happen with you and your students. That's actually one of the most important things you can say in this moment. And we found that, they just gave beautiful testimony that really just highlighted the issue. And so at the end of it, you have this amazing record where it really can't be disputed what the impact is going to be on this community.
So despite all of that work, CPS still decided that they wanted to close this school, despite our beautiful administrative record. So in February 2018, they officially approved a final decision to close NTA. In June 2018, on the last day of school, we filed a complaint in state court, which Candace will walk through the claims in a second. But our complaint challenged the whole school action related to NTA on several different grounds. In July, we filed a motion for a preliminary injunction, including affidavits from 6 different expert witnesses to kind of shore up all the harm that would occur and how this was discriminatory. Then in August, CPS filed a motion to dismiss all of our claims, and we entered into an expedited briefing schedule. So we actually got to oral argument by October 2018, which was great because anyone in here who has CPS students know that applications for schools and everything like that really gets going in first semester. So we were kind of under a time constraint. And then thankfully on December 3rd, we got a favorable decision. Our injunction was granted. And then even more exciting, so the injunction was granted around 3 or 4 in the afternoon. Then we started to hear rumblings that they wouldn't appeal. And then by about 8 p.m. that night, CPS formally announced that they would not proceed with this action at all. So they abandoned the plan. NTA will stay open as an elementary school, but that's the first time that CPS has approved a school action and taken it back, and it's the first time that an Illinois court has actually intervened in one of these cases to tell CPS that what they're doing is discriminatory.
And so just briefly, I'll sort of touch on the claims. So we filed a 5-count complaint. We filed 4 claims under the Illinois School Code saying that CPS violated the Illinois School Code in various ways, specifically in how they really didn't have they really didn't use any criteria to even initiate the school action. They said they got a community request, but the community requests were people largely not from that community, that school community, that were requesting that school be turned into a high school. They really couldn't point to anyone from that school who said they wanted this plan, that they didn't follow their own guidelines, that the school that they were sending the students to was not actually higher performing. At the very best, it was equally performing, but the law actually requires higher performing. And then they had an inadequate transition plan. We also filed a claim under the Illinois Civil Rights Act. And here we filed it under a theory of disparate impact, claiming that the way in which CPS made the decision, the criteria that they relied on, was so racially biased that it had a discriminatory impact on African American students. So without getting too much into the weeds, basically you can look at school performance in a couple of different ways. CPS chose the way that has one of the largest racial gaps just inherent in how we look at testing. And they know it. They actually don't use it as how they sort of quantify schools, but for this particular decision, that's what they decided to hang their hat on, and that's what we challenged, in showing that by using that measure, any school with majority black students would fail, would lose under this plan, regardless of any other factors. And it turned out when the judge made his decision, none of our school code claims survived. So that was really tough for us, because when we were planning, in some ways we thought those might be the strongest claims, and that maybe a judge might shy away from the race-based claim. And the only claim to survive was the ICHR claim, and it won the preliminary injunction. So that was a really powerful moment for us. It was a really powerful moment for our clients, which was really important. And so I think we take away from this just the power of community lawyering, what it means to really invest in our communities, what does it mean when they have power, when they're able to speak up and show up and really support this case. This case would not have been what it is without all of their work, and we're deeply grateful for that. And then just the power and the courage to litigate these cases and call it what it is. It's a race equity issue. This is racism, and how do we begin to think about different ways to bring that up through the law? Yeah, so we'll pause there. Is there any questions?
Go down the line.
Yeah.
Okay. Good afternoon. Can everyone hear me?
I think you're still have to pull it out. A few people in the corners can't.
Okay. So in the Chicago area 10 years ago, there were 17 coal-fired electric generating units. In the Chicago area today, there are 3 that are still operating. What does this mean as a practical matter in terms of reductions of air pollutants? Every year, it means reductions of 52,000 tons of sulfur dioxide. Sulfur dioxide is an acid. Sulfur dioxide also contributes to fine particulate pollution, both of which cause respiratory illness. It means annual reductions of 18,000 tons of nitrogen oxides. Nitrogen oxides are an ingredient of ozone, smog, and Chicago is a very challenged area in terms of ozone conditions. Perhaps most remarkably, it means reductions of 20 million tons per year of carbon dioxide, the greenhouse gas, the climate changer. Going from 17 to 3 coal-fired power plants also means similar reductions in particulate matter, mercury, and other hazardous air pollutants. Now, over this 10-year period, several governmental and non-governmental organizations participated in achieving this result. Having said this, the capstone of all of this work was the 2018 entry of a consent decree in federal district court in Clean Air Act litigation, in which the Chicago Legal Clinic represented the only non-governmental organization in the case, a grassroots organization called CARE, Citizens Against Ruining the Environment. So how do we get here? Ellen Rundelich is a resident of Lockport, Illinois. Her home in the kitchen has a back window. When she would look out her back window, she would have an almost perfect vantage point on the smokestacks of 4 coal-fired units at Midwest Generation's Romeoville facility. And she frequently saw over years, coming from these stacks, black smoke. And Ellen knew from her conversations with people who lived in other communities with coal-fired plants in Pilsen, Little Village, Waukegan, on the southeast side, in Joliet, that black smoke meant that the smoke that was coming from these coal-fired power plants was entrained with soot. And this soot would fall out and be most endangering to the communities closest in to these coal-fired power plants. Ellen's story was not only anecdotal, it was actually confirmed on the complete opposite end of the spectrum by an analysis which had been done by the Harvard School of Public Health, which looked at who was impacted by the emissions of coal-fired power plants, especially in densely populated areas like the city of Chicago. The Harvard School of Public Health concluded that black smoke actually was creating higher incidences of asthma, hospitalization, and even mortality. So that's Ellen's story, but Chicago Legal Clinic. How does Ellen Rundelich, living in Lockport, Illinois, decide that she is going to connect with the Chicago Legal Clinic on an environmental law case? It's not as unlikely as it seems. In the late 1980s, the South Chicago Legal Clinic established one of the first environmental law practices in the country. And at that time, it was a relatively simple matter because the South Chicago Legal Clinic was based on the southeast side of Chicago, and any legal service organization that was attempting to be responsive to a community on the southeast side of Chicago would naturally see that environmental legal services was something that would be valuable and important for local residents. As the Chicago Legal Clinic grew to be a regional legal service provider, the environmental law program grew as well. 20 years ago, we became the environmental law program, the Environmental and Energy Law Clinic of the Chicago Kent College of Law, which means that every semester, spring, summer, and fall, I have 8 to 12 law students who work with me to provide environmental legal services to groups in the Chicago area. We also entered into a service learning agreement with Northwestern University's Department of Civil and Environmental Engineering. They create teams of professors and students to address technical aspects of the really complicated cases that we take on. So when Ellen was looking for legal services to address the black smoke problem, she very quickly found her way to the Chicago Legal Clinic. This led to more than 2 years of information gathering and analysis about the operations of these coal-fired power plants. During this period of time, CARE became aligned with several national organizations which also wanted to address emissions of dangerous pollutants from Chicago area coal-fired power plants. These included Sierra Club, National Resources Defense Council, Environmental Law and Policy Center. Together, we worked together to develop a detailed notice of intent to sue the operator of the coal-fired power plants. We filed a complaint that was eventually joined by the United States and Illinois through the active efforts of the Illinois Attorney General. We survived the inevitable motion to dismiss, began initial discovery, and based on information we gathered, amended our complaint. Now here's where CARE becomes so important. As part of the interim agreement during this litigation to shut down the coal-fired power plant in Pilsen and in Little Village, the other non-governmental organizations, the national groups, agreed to leave the case, which means that the only NGO that has been a part of this case since 2012 is Citizens Against Ruining the Environment. CARE has no paid staff. When they meet in the public library meeting room. Their litigation committee, Carol, Sandy, Ellen, and Mary, meet around Ellen's dining room table. I've had 30 generations of environmental law students eat Subway subs sitting at Ellen's dining room table trying to address unbelievably complicated litigation and technical issues related to the operations of these coal-fired power plants. We had to wait out an interlocutory appeal. We had to wait out a bankruptcy when the operator of the coal-fired power plants collapsed. When the plants were bought out of bankruptcy, we had to set up the structure of negotiations with the new owner. The new owner, by the way, represented by Schiff Hardin and by Jones Day. Perhaps most importantly for CARE's engagement, we had to maneuver through the complicated dynamic when federal priorities regarding coal shifted at the tail end of this case. It was because CARE refused to consider stepping back, refused to consider doing less than what had been the structure of a settlement, that the settlement actually went through in the way that it did. Also have to pay props to the Illinois Attorney General for standing up as well. That was helped by the fact that Stephen Sylvester, the attorney from the Illinois Attorney General's office who worked on this case, was one of my former clinical students. So who are the beneficiaries of this case and this consent decree, this comprehensive, this universal settlement that removes these coal-fired power plants and achieves these dramatic reductions in air pollutants? One, Citizens Against Ruining the Environment. In Will County, where CARE is based, there used to be 9 coal-fired power plants. There is now 1. It is much better controlled, and it only operates on an interim basis. The clinical law students who worked on this case are beneficiaries. What an incredible learning experience for them to participate in complex Clean Air Act litigation, and what a remarkable achievement for them to take out of their law school experience. Other beneficiaries, everyone in this room, regional air quality for everyone is substantially improved, but especially for the environmental justice communities in closest proximity to these former coal-fired units. What does this also mean in terms of beneficiaries? The regional contribution of the Chicago area to GHG emissions, climate-changing emissions, has been dramatically, exponentially reduced. These coal-fired power plants were by far the largest source of GHGs in this region. I also want to point out the lights are still on. And that brings up the point that a case like this helps facilitate the transition to a post-coal combustion energy economy. And we in the clinic have now moved on to the implementation of Illinois' remarkable Future Energy Jobs Act, which will permanently replace fossil fuel generated power with non-carbon sources of power, and for the benefit of the kinds of communities that we want to serve. So, thank you.
Hi, everyone. I'm Tanya Gassenheimer with the Chicago Coalition for the Homeless, and I'm going to talk about our efforts along with the Shriver Center and Heartland Alliance to enact a statute that we call the College Hunger Bill that expanded eligibility for Illinois community college students who are in Perkins-approved courses of study. I'll first talk about kind of what the law says, and then go through the trajectory, the history of the effort and how we got here, and then talk a little bit about the impact of it. So what the law does is it allows community college students who are in Perkins-approved courses of study to be eligible categorically for SNAP benefits, erasing a prior requirement for college students to have an additional work-related requirement, that they work in addition to being students just to be eligible for SNAP benefits. Now, as long as they're in the list of approved courses and they're in a community college, regardless of whether it's part-time or full-time, they are now eligible. All the approved programs are listed in our brochure. We and the coalition created a brochure that's available outside on the table if you didn't get a chance to pick it up. It goes through eligibility and then how to get students connected. We encourage potentially eligible students to have someone from their school fill out a verification and sign off for them. It's not technically required, but we think it would be helpful. And a link to that is also on CCH's website. And any questions, you can feel free to reach out to us. So how did we get here? This effort actually started 7 or 8 years ago. The coalition has been talking about doing this since back then. It started when Quinn was governor, and his administration was open to the idea and kind of very positive about it. But his administration, they wanted to roll out the Affordable Care Act, Obamacare, first before getting to this. And then, as you all know, things didn't go so well for him. He got voted out. And then the Rauner administration came in. They also expressed interest in it, but didn't make it a priority, didn't get around to doing anything about it. So in 2017, we introduced a bill to make the change statutorily. It passed both houses, but then Governor Rauner issued an amendatory veto. His main issue with it was that in that iteration of the language, colleges across Illinois would have the burden of informing any eligible student of their eligibility by including a piece of paper to that effect in their financial aid packages. And he felt that was too burdensome. So he issued the mandatory veto, and it died, at least at the time. So then we kind of went back to the drawing board, kept at it. In the fall of 2017, we introduced a new bill with new language that reflected Rauner's issue, so it took out the burden on the colleges and universities to inform the students. Also at that time, this was around the fall of 2017, the Department of Human Services announced that they would adopt a rule change to the same effect that would make this group of students eligible, but they were not clear. It was very vague. It wasn't clear how they were going to do it or when or kind of the process to make it happen. So not fully trusting them, the advocates involved kind of kept going with the legislative effort. It didn't get done at the end of 2017 just because of some kind of logistical issues with session. So then the advocates involved picked it back up in 2018. It got through both houses, and then Governor Rauner signed it into law in July of 2018, which was a big victory for all of these students. And I think the impact of it, it's important to, first and foremost, of course, it makes over 40,000 students now categorically eligible, which is huge, because especially for those who rely on this program, it provides them access to food, which of course is one of the most basic necessities, and especially for students as they pursue higher education, that's something that has a huge impact. It also shows that it can take many years, but something that advocates were seeing day to day, as Rebecca was talking about in our work with individual cases, individual clients, seeing a certain pattern over and over again when advocates kind of band together to address an issue like that and get creative, it can have wonderful effects, and in many different ways, because there are multiple avenues to advocacy. This resulted in a change administratively, a change legislatively to the statute. So it shows that there are various ways to kind of move advocacy forward. And another big thing that we think to take away from this is that it alters what, there really isn't a traditional student anymore. So this can have an impact to people of all ages. Our organization works with folks experiencing homelessness. It affects that population, but also beyond. And I think most folks in the room here come across people at various points who are pursuing higher education, regardless of what they may be seeing us for. So especially because of the change in the language of the statute due to Rauner's mandatory veto, now that colleges don't have the obligation of informing eligible students of their eligibility, a big thing to take away is that it's on us now to make sure we're aware that this change in the law has taken effect, and that we spread the word far and wide, and make sure as many potentially eligible students know that this is out there to support them through their studies. And so we are constantly looking for ways to spread the word, to connect students to it. So if anyone has ideas, we've talked to CPS, guidance counselors, and different folks who may come across students who are either in college now or maybe thinking about that very soon. So any ideas or feedback is always welcome. We'd love to hear from you all. And that's it from me.
So I'm supposed to talk about 3 big class action cases, which combined took about 25 years to litigate, and a few minutes. So I may have to simplify a tad. But I want to start off by talking about some individuals. A paperclip, a baseball cap, and a dollar. Anthony was at TAMS, our Supermax prison, serving effectively a life sentence. A paperclip was found in his cell. Somebody decided, therefore, that he was hiding his shoes, so the remedy was to take his shoes away. He developed a blister. They didn't treat it. He's a type 1 diabetic. Went out to an outside podiatrist, got all kinds of cleaning out of it, et cetera, gets transferred from TAMS when it closes down, takes to Pontiac, doesn't get any health care at all for months and months at Pontiac. It continues to get worse. He develops infection of the bone. 3 years after they took the paperclip, they found the paperclip, he lost half his leg. That's the kind of medical care we're providing in Illinois Department of Corrections. Gangrene set in and they had to amputate the leg. Another Anthony, different Anthony, Anthony Gay, stole a baseball cap and a dollar from another teenage kid. He got sentenced to probation. Not an unreasonable sentence for that. But he violated probation, so he ends up in the Department of Corrections, gets into a fight with a cellmate, gets into solitary, and his mental health deteriorates significantly. He picks up a lot of new cases in prison, throwing things on guards, self-mutilating, et cetera, ends up with a 99-year sentence from what started as probation. His mental health continues to deteriorate. He starts self-mutilating, cutting on himself first, a way to get out of solitary. He's now in solitary pretty much his entire time in prison. When that doesn't get him the sort of mental health care he needs, he ups the ante. He learns how to hurt himself very creatively, does things that, if anybody's eating, I will not describe to you, but things that are just horrifying. Northwestern comes in and gets his sentence reduced. Technicality said, no, you don't get 99 years. He's out now. For the last couple of months in prison, he finally got good medical care, stopped cutting on himself entirely, stopped going to outside hospitals, and got off of enforced medication, which he's been on for years. So the moral of that story is if we actually provide mental health care, people can actually get better. People can actually survive. I tell you those stories because these are big class action cases that deal with all 40,000 prisoners in the Illinois Department of Corrections, but it's important to keep in mind that these problems affect individual people. Individual people whose lives are going to be changed forever because of the way we maltreat people in our prisons. Anthony's out, he's doing well. Anthony Gay is out, doing well. But the mental effects of what he went through for the last 2 decades plus is going to be with him for the rest of his life. So we have 3 lawsuits that we filed in 2007. Mental health care case and mental health care throughout the Illinois Department of Corrections is unconstitutional. Case is called Rasho. It's described in our handout. 2 years ago, in the spring of 2016, the court approved a settlement agreement between us and the state of Illinois, calling for an overhaul, new people, new training, actual mental health care for lots and lots of people who desperately needed it. The state has not held up their end of that bargain. We went back into court first in the spring of 2018 and got a preliminary injunction ordering them to comply with various provisions of the settlement agreement. They didn't do that either. So last fall, we went back to trial on a permanent injunction, which in late December was issued by the judge with some quite dramatic findings about how desperate the situation is and how we have an emergency in our prisons that they have to deal with, and that they've ignored this problem for far too long. In terms of medical care in 2010, in that case we're co-counseling with Equip for Equality and Dentons as our pro bono partner. In 2010, filed a medical class action case to help people like Anthony Rudetsky, who's lost his leg. Our partners there are the ACLU and Dentons. Just this morning, the preliminary consent decree was found by Judge Alonzo to satisfy the first stage. It's likely to be approved. Therefore, notice the class is going out. Assuming it gets its final approval in about 120 days, it will call for hiring a lot more doctors, a lot better doctors, and improving the quality of the doctors. You may be appalled to learn that people who are in charge of medical care at some of these prisons are not trained as internists or general family practice. We have radiologists running one of these prisons, surgeons running one of these prisons, people who have no business in this business at all, people who do not know the difference between type 1 and type 2 diabetes, are making decisions about health care for people, stuff that anybody should have learned in the first year of medical school. So all that is down the road, but it's a huge change, and assuming the state actually does what they're going to do, mental health care and medical care over the next few years will be significantly improved for all 40,000 people. The third of the cases is about deaf and hard of hearing people. Imagine being in prison is a pretty isolating experience no matter what. Now imagine being there and not being able to hear anything at all. The state of Illinois had not provided such simple things as ASL interpreters for things like disciplinary hearings or medical appointments. There was a man who had serious heart problems and was required to write notes, was their version of how you communicate with your doctor. He didn't understand the details of what he had to do in order to take care of himself. Health deteriorated, ultimately had a heart attack, or maybe it was a gallbladder infection that exploded, and died in a hospital without being able to communicate with anyone around him, without being able to talk to the doctors. That was one of our main plaintiffs. That case we did with Equip for Equality in Winston and Strong. We also have a settlement agreement in that one that we entered into this year. We're in the process of enforcing it. Just last week, we were in front of the judge for our first quarterly report to the court as to whether or not they're complying. They're a little behind, but they're making some progress. So it's not a disaster like some of the others. So all of these cases started by people writing us or people that we knew from other cases who had these sorts of problems. There are a lot of prisoners, and a lot of them have a lot of legal problems. We can't address them one at a time. There are just never going to be enough lawyers to address all of the problems that exist in our prison system. So we very much work to try to package those things together, figure out what the trends are, figure out a legal theory, find a partner who can take it on with us, or partners in every one of these cases, and try to come up with systemic solutions to these problems. But it's important that we always keep in mind that there are individuals that are impacted by these decisions. It is not sort of broad-based theoretical thing that we have bad medical care. It's people who are dying. The most recent medical expert found dozens of people who had died in the Illinois Department of Corrections, in circumstances that could have been alleviated or perhaps prevented altogether had they gotten decent medical care. We spend an awful lot of time going to prisons, talking to the individual prisoners at cell front in our mental health case, but in the visiting room otherwise, and reviewing people's letters so that we remain grounded in the individual stories that exist out there.
Well, thank you so much for your presentations. It's really amazing work and so inspiring and incredible. And I think at this point in time, we could all use some good news. I don't know about you, but it's so important for me to hear these stories and to be reminded that we really do have the power to change laws and to change lives. So thank you again. We do have some time. So does anybody else want to share their highlight from your organization? I'm going to call on people if no one volunteers. Is anyone here from Philly? Would you want to share some of your, I know you had a number of them on there. Do you feel comfortable? Sure. Sorry to put you on the spot.
My name's Shelby Smith, for those of you who don't know me, and I recently graduated law school and passed the bar, and I'm the Equal Justice Works Fellow at Hilly, and I'm starting a new project called Legal Help Within Reach. The idea is to take attorneys, pro bono attorneys from urban areas to less populated rural areas to provide needed legal services in a one-day clinic. So I guess the exciting news is my first clinic is going to be in the beginning of April. It's going to be a Willem Powers of Attorney clinic outside the Rock Island area. So it's exciting. And if you have any more questions or ideas, feel free to reach out to me. It's smith@pili.org.
Anybody else want to share? Is there anyone here from the Moran Center? I told you I was going to call you.
I never need a microphone. So I'm Patrick Keenan-Devlin. I'm the executive director. Actually, I need a microphone for those people, right?
Here, take a microphone.
I'm not going to sing for you. No, I'm not going to sing. That's why I don't need a microphone. My name is Patrick Keenan-Devlin. I'm the executive director of the James B. Moran Center for Youth Advocacy. I didn't look at which highlight you picked, but I'm guessing which one you're talking about. So we partnered with the John Howard Association, the Juvenile Justice Initiative, and our pro bono partner was Kirkland & Ellis. There were 20 prosecutions of children from the Illinois Youth Center at Harrisburg, which is a facility run by the Illinois Department of Juvenile Justice. The Saline County State's Attorney prosecuted these 20 young people, either transferring them from juvenile court jurisdiction to the adult criminal system or charging them as adults, because some of them actually matriculated as adults within the IGJJ system, prosecuting them for aggravated batteries, aggravated assaults against staff members that typically would have been treated in-house as disciplinary infractions, but given that the staff at IYC Harrisburg was very upset that they could no longer hold children in solitary confinement, they actually would walk out of the facility to the Saline Police Department and report aggravated assaults and batteries against these children. And then Saline Police Department would come into the facility and arrest the children, transfer them to Saline County Jail, and then prosecute them. The ranges of prosecutions were anywhere from about 3 years at the low end to about 8 years at the top end in the Illinois Department of Corrections. We're working with attorneys right now. There's still a few cases that are pending from IYC Harrisburg in the Saline Circuit Court to get attorneys to represent those children, those young adults in the criminal courts. But we really are very grateful as Governor Rauner is exiting office. We filed, not really petitions, we basically put together we're begging you, help some of the kids that are in the Illinois Department of Corrections now. And the governor commuted 6 sentences, which we're really excited about. But we're still working with pro bono partners to try to, during their mandatory supervised release periods, to get them post-conviction relief, because it was not a full pardon issued by the governor, so they still have felonies on their backgrounds. And we all know in this room what a felony does to your prospects out post-release. So that's an update. I probably talked way too long, but that's it.
Anyone else? Does anyone here have a lawyer case about housing?
Yeah, my name is John Rapanda. I'd like to talk about Dan Lesser or Shriver. The TANF grants had not been increased till 2008. So a mom with 2 kids gets how much? $432. Dan went to Springfield with a Delta team, and now it's not much, but it's 30% of the poverty rate. So mom is going to get an extra $70, $75. And there's a built-in COLA because it's triggered to the poverty rate. And while we like to pat ourselves on the back about being a blue state, let's keep in mind that Michigan and Wisconsin have higher TANF grants than we do, even with this increase. Thank you.
They're all amazing. Like Rebecca said, we could have chosen literally any of them and they would have been inspiring, but we thank you guys for speaking. We thank those of you we put on the spot for speaking as well. I will say, Carolyn doesn't want to speak, but there's a new Supreme Court rule that's in there that Seidel worked on and a bunch of other people in this room worked on, so you should definitely check that one out if you can. I will send this around via email, so you'll get it either later today or tomorrow. So please do share it more widely. And I think, Rebecca, maybe we have one more thank you.
We wanted to thank Laura Hernandez, who is a new intern at the Chicago Bar Foundation, who helped to put this booklet together. It looks great, and like Angela said, thanks so much. It looks fantastic, and like Angela said, please share it with anyone you know who might be interested in thanks for coming, and we'll see you next month. Announcements.
This is not a highlight. I just want to make a quick announcement. Allison Spanner from the Access to Justice Commission couldn't be here today, but wanted to let everyone know that the Commission is hiring a new person, a senior program manager, to oversee their statewide forms development work and work on other access to justice initiatives. If you're interested in learning more, please reach out to her. They're accepting applications until next Friday, so let anyone who knows who's interested in policy work and access to justice.
Thanks, Sarah. Any other announcements? Anyone? Okay, thanks for coming. See you next month.